Hey there, fellow gun lovers. Picture this. You roll up to your local sheriff's office, ready to apply for your concealed carry permit, only to hear, "Sorry buddy, you don't have a good enough reason." That's been the reality for folks in places like New York or California for ages, until the Supreme Court dropped a 6-3 bombshell that's got the gun community buzzing. This isn't just some dusty legal ruling, it's a seismic shift for anyone who carries, wants to carry, or just believes in the Second Amendment. We're talking game-changing stuff for how you protect yourself and your loved ones. Here at Survival Gear Showcase, we're slicing through the noise to give you the straight dope. No fluff, just facts, with a side of real-world carry tips. Whether you're rocking a Glock 17 or a snub-nosed 38, you need to know this. Hit that subscribe button for more on the best carry gear, ammo tests, and your rights. We've got your back. The 6-3 ruling that shook things up. Let's dive into the meat of it. New York State Rifle and Pistol Association Inc. v. Bruen. Back in June 2022, the Supreme Court handed down a 6-3 decision that gut-punched New York's century-old concealed carry law. For years, New York demanded you show proper cause to carry a concealed firearm. And no, "I want to protect myself" didn't cut it. You needed some special circumstance, like a documented stalker or a job hauling cash. Didn't have that? Tough luck. Permit denied. It was a system that left law-abiding folks defenseless while criminals, well, didn't exactly follow the rules. Justice Clarence Thomas, writing for the majority, wasn't having it. He said loud and clear that any law messing with your Second Amendment rights has to square with text, history, and tradition. Translation? If it wasn't restricted back in the 1700s or 1800s, it's probably not cool today either. Forcing you to justify your constitutional right to carry? That's a big nope. The Second Amendment, tied to the 14th for state application, doesn't play games with subjective red tape. This ruling smashed the idea that you need to beg for your right to self-defense. It's not just a win for New Yorkers, it's a beacon for every armed citizen in restrictive states. Think about it. You're at the range, practicing with your SIG P320, honing that draw for real-world scenarios. Under the old rules, you could ace every safety course and still get denied a permit because some clerk didn't like your reason. Now, the court's saying your right to bear arms is enough. It's like clearing a stovepipe jam. Suddenly, things are moving again. Ripple effects across the country. This ruling didn't just shake up New York, it sent shockwaves to every state with similar may-issue laws. Think California, New Jersey, Maryland, Hawaii. These places operated like gatekeepers, doling out permits at their whim. Want to carry your Ruger LCP in LA? Better have a VIP-level excuse. Bruen changed that, pushing states toward shall-issue systems. If you pass the background check, complete the training, and meet the basics, they have to issue your permit. No more, we don't feel like it. But don't pop the champagne yet. Some states are digging in their heels, throwing up new hurdles faster than you can swap a mag. New York, for example, passed a revised law that turned half the state into sensitive places where carry is banned. Times Square, subways, parks, even churches. It's like saying you can carry, but only in your backyard. Critics, including groups like the Second Amendment Foundation, call it a middle finger to the ruling, making legal carry nearly impossible. When challenged, the Supreme Court didn't step in yet, leaving lower courts to slug it out. Other states are following suit with tricks like jacked-up fees, month-long waiting periods, or training courses that cost more than a decent AR-15 lower. Here's a real-world angle. A buddy of mine in Maryland applied for a permit pre-Bruen. He's a small business owner, carries cash deposits, but got denied because general self-defense wasn't good enough. Post-Bruen, he's got his permit, carries a Springfield XDS, and sleeps better knowing he's not defenseless. But in places like Jersey, new rules mean you're jumping through hoops. Think 20-hour classes or character references that feel like a job interview. It's a fight, folks, and it's far from over. The new legal yardstick: text, history, tradition. Here's where Bruen gets nerdy but awesome. The court set a new test for judging gun laws. Does it match the Constitution's original text? Is it backed by how firearms were regulated in early America? No more leaning on public safety vibes or what some politician thinks is reasonable. If a law bans your 15-round mag or says you can't carry your 1911 in a park, it better have a historical twin from the founding era. Spoiler, most modern restrictions don't. This is huge. Federal courts are already wielding this test like a well-aimed shot. California's 10-round mag limit struck down in Duncan v. Bonta because there's no 1790s law capping how many musket balls you could carry. Transportation rules forcing you to lock your Glock in a safe during travel. getting shredded for lacking historical roots. It's like the court handed judges a time machine and said, "Go check the 1800s rulebook." For us, it means restrictive laws are dropping like spent casings at a busy range. Ever try explaining to a non-gun friend why you carry a spare mag? It's not about paranoia, it's about being ready. Now, imagine defending that in court against a ban. Bruen gives you a leg up by demanding historical proof. No founding-era law banned extra ammo or your favorite carry piece? Then it's likely unconstitutional. This test is reshaping the legal landscape, and we're just seeing the start. How this hits everyday carriers. If you're in a gun-friendly state like Texas or Arizona, where constitutional carry or easy permits are the norm, Bruen might not change your daily routine. You're already strapping on your CZ P10C without jumping through hoops. But for folks in restrictive states, this is a lifeline. Thousands who got denied for vague reasons, not special enough, can now get permits if they meet standard requirements. It's a power-up for your right to self-defense. For you, this means staying sharp. Know your state's laws inside out. Check sites like handgunlaw.us for updates. Invest in a good holster. I've tested plenty on the channel like the Tier 1 Concealed Access Elite, solid for appendix carry. And practice your draw in scenarios where you're calm under pressure, because legal carry doesn't mean easy carry. Bruen strengthens your rights, but you've got to wield them wisely. What's next for gun rights? All right, let's keep rolling. Bruen isn't just a one-and-done win. It's the opening salvo in a new era of Second Amendment fights. This 6-3 ruling lit a fuse, and courts nationwide are now wrestling with gun laws under this text, history, and tradition test. We're talking everything from magazine caps to so-called assault weapon bans getting put under the microscope. Want to carry your AR pistol with a 30-round mag? Or keep your Beretta 92FS loaded in your car without a lockbox? Bruen's framework is forcing judges to dig into history, and if there's no 1791 equivalent to a modern restriction, it's likely toast. Take California's magazine limit as an example. Duncan v. Bonta already tossed their 10-round cap, citing no historical precedent for restricting ammo capacity. Or look at Maryland's handgun roster, which limits what you can buy based on arbitrary features. That's under fire too, with courts questioning if the founders cared about grip angles or rail attachments. It's not just local laws either. Federal rules, like ATF's latest on stabilizing braces, are getting challenged for lacking roots in the 1800s. This is a chain reaction, folks. Every time a law gets struck down, it sets precedent for the next fight. But here's the catch. Not every court's on board. Some judges are slow-walking this, finding creative ways to uphold restrictions by cherry-picking history. Meanwhile, states like New Jersey and Massachusetts are pushing back with new laws dressed up to look Bruen-compliant but still a pain for carriers. Think mandatory 40-hour training or requiring 3 character witnesses who've known you for a decade. It's like they're saying, sure, you can carry after you climb Mount Paperwork. Lawsuits are piling up in Illinois, Oregon, and beyond, and some will likely hit the Supreme Court again. This ruling sparked a wildfire, but we're still fighting to keep it burning. For us gun folks, this means opportunity and responsibility. More states might move to constitutional carry. 29 yet already have it, like Tennessee with its permitless handgun carry. But even in those states, know the fine print. Bruen helps in court, but it doesn't stop a bad day on the street. Staying informed and locked in. Let's get real. The opposition isn't rolling over. Anti-gun states are crafting sneaky workarounds, like New York's sensitive places list that's basically everywhere you'd actually need to carry. And the media? They'll spin every ruling as either Armageddon or a nothing burger depending on the outlet. That's why you've got to stay sharp as a fresh zero on a red dot. Being a responsible gun owner isn't just about nailing your groupings at 25 yards, it's about knowing your rights and the laws down to the letter. Start with the basics. Check your state's carry laws regularly. They're changing fast post-Bruen. Sites like the USCCA or Firearms Policy Coalition break it down plain and simple. If you're building a new EDC setup, maybe a compact Springfield Hellcat with a Holosun optic, make sure it complies with local rules. I've reviewed rigs like that on the channel, and trust me, a good holster can save you from printing drama during a stop. Also, document everything. A cheap dash cam can be a lifesaver if a cop misreads your lawful carry as a threat. Support the heavy hitters too. Groups like Gun Owners of America and the Second Amendment Foundation are out there fighting in courtrooms so you don't have to. They're the ones taking on California's roster or New Jersey's mag bans, and they need our backing. Share their updates, talk to your buddies at the range, spread the word. Knowledge is power, and we've got to keep the community tight. Wrapping it up. What do you think? Was Bruen overdue, or are states still making it too hard to carry? Drop your thoughts in the comments. I read everyone and love hearing your take. If this breakdown helped you get the lay of the land, smash that like button and share it with your range crew. Subscribe to Survival Gear Showcase for more on carry laws, gear tests, and staying ready. Stay safe, stay informed, and we'll catch you in the next one.